The court drama between WordPress and WP Engine is getting crazy. If you're in the ecosystem, there will be a lot for you in this video. My name's Dennis, I'm an intellectual property attorney and software developer, and in this video I'm going to briefly cover the spat between WP Engine and WordPress, and then I'm going to explain what's been filed in court, who I think is likely to prevail, and what the ramifications for WordPress, WP Engine, and WP Engine's users could be. Okay, so in case you haven't heard or you're new to this, in September, WordPress co-founder Matt Mullenweg launched himself and WordPress into a catfight with WP Engine. WordPress is an open source content management system, and WP Engine primarily helps website owners and maintainers host their WordPress websites. In September, Matt threatened a scorched earth nuclear approach, starting with a keynote speech at a WordPress conference if WP Engine did not pay Matt for a trademark license. The proposed one-page trademark license agreement called for 8% of WP Engine's gross revenue. That would be tens of millions of dollars a year. WP Engine predictably refused, and the circus began. Matt first started his nuclear destruction by threatening to ban WP Engine from the WordPress community unless WP Engine agreed to the license. Then, at the conference, he said that WP Engine feeds off WordPress without giving anything back, and that every WordPress Engine customer should not renew their contracts.
Who's a WP Engine customer in the audience? Don't feel bad. Okay, there we go. By the way, I've had a few people come up, and the other thing that makes WP Engine tricky is their misuse of the trademark, that they're very cavalier with it. How many people have heard it called WordPress Engine before? Yeah. Okay, we got a few there. People have come up to me. I get support requests sometimes for WP Engine because people think it's like an official thing. Their logo's blue. They call it WP Engine. They think it's like something official that's part of the community and giving back and building WordPress. And so that's what makes it so insidious.
As I'll get into later, when you hear attorneys and clients say to keep your mouth shut about potential or ongoing litigation, this case will truly stand as the number one reason why that's a good idea.
It's like you're calling for a strike from end users, developers, so on and so forth.
Well, I hope that we can get every single WP Engine customer to watch this presentation, and that when their renewal time comes up, they think about that. And there's some really hungry other hosts, Hostinger, Bluehost Cloud, Pressable, etc., that would love to get that business. And migrating has never been easier. That's part of the idea of data liberation. So again, it's kind of like one day of work to switch your site to something else. And I would highly encourage you to think about that when your contract renewal comes up if you're currently a customer of WP Engine.
Thanks, Matt.
So then the words turned into action. Matt removed WP Engine's access to WordPress.org. That's an online marketplace for WordPress. They took control of WP Engine's plugin, Advanced Custom Fields, and renamed it to Secure Custom Fields. Automatic then made customers take a loyalty oath to sign into the WordPress site, stating they had no affiliation with WP Engine. And Matt continued to run his mouth publicly with statements like they're all going to war with WP Engine and they're going to take every single one of their customers. Finally, on October 3rd, WP Engine had enough. They filed a lawsuit against Automatic, WordPress's parent company, and Matt Mullenweg himself. They allege interference with contract and economic relations, computer fraud and abuse, attempted extortion, unfair competition, promissory estoppel, libel, slander, and they seek a declaratory judgment that they did not infringe or dilute trademarks. Shortly thereafter, WP Engine filed a motion for a preliminary injunction, asking the court to return the status quo pending the lawsuit. Automatic responded to the injunction, and WP Engine filed a supplemental reply. Automatic also filed a motion to dismiss. So as I read through the documents, a few things stuck out to the attorney in me. First, Matt Mullenweg is being sued personally. I initially thought that this was crazy and would get the ire of the court for bringing a personal suit against a person clearly shielded by corporations. But then in the suit, I learned that Matt himself owns and controls WordPress.org. Because of that decision, his house, his cars, and the phones that he used to run his mouth are all potentially up for grabs. The second thing that struck me is this is mega-powered law firm against mega-power law firm. Neil Katyal is listed as representing Automatic. Neil is the former Solicitor General of the United States, and that's the person who argues on behalf of the government in the Supreme Court. He's also a frequent talking head on news shows. I doubt he knows anything about the case, but that he's included is interesting and shows how much Matt is willing to pay. So the third interesting thing of note is how hard WP Engine in their briefings are signaling tax fraud. Apparently in 2010, Automatic transferred the WordPress trademark to the WordPress Foundation, ostensibly to promote open access and alleviate public concerns over private control. However, Automatic and Molenweg then arranged for Automatic to have an exclusive, royalty-free perpetual license for the trademark on the same day, effectively retaining control while creating the appearance of a nonprofit stewardship. The complaint accuses Matt of failing to disclose this licensing arrangement in the WordPress Foundation's IRS filings and in public statements. The complaint suggests this omission misrepresented the Foundation's control and independence over the trademark, leading to potential annulment issues under tax law. The filings did not report any valuable assets, such as the WordPress trademark, nor did they disclose a licensing arrangement as a related party transaction, which federal tax law requires. The next takeaway was probably the biggest stunner to me. Automatic justified removing WP Engine from WordPress.org by stating, essentially, that they gave no assurances of access to anyone and it was at the risk of the individual businesses. They made it sound like these businesses were freeloading off WordPress.org like a bunch of stray dogs tagging along that should expect to be let go at any moment. As I'll discuss more later, it's not a terrible legal argument, but as a business argument, every business that ties into the WordPress.org ecosystem needs to figure out a different plan. The next thing of interest is that the judge is new to the bench and an immigration law attorney, so she's unlikely to know much about the litigants or the subject matter. That could be a good thing, it could be a bad thing. It's something to watch on her initial rulings if she's taken the time to come up to speed. And my final takeaway on this is how bad Matt's comments look on pleading paper. As I'll get into further, Automatic has some good legal defenses in the abstract, but against the backdrop of Matt's rants, it torpedoes everything. So with that, let's get into the complaint. In a complaint, you state the purpose and the scope of your lawsuit. You give the law and the relevant facts. You also typically throw any colorable cause of action, even if they aren't likely to win. In the motion for preliminary injunction, WP Engine focuses on computer fraud and abuse, attempted extortion, contractual interference, and unfair competition, so we'll just stick with those. A preliminary injunction asks the court to enjoin a party from a specific act before the actual case is decided. In this case, WP Engine wants access to WordPress.org, control of its plugins, and Matt to stop running his mouth. So to succeed with a preliminary injunction, the moving party must show 4 factors. 1, that it's likely to succeed on the merits. It's likely to suffer irreparable harm in the absence of a preliminary relief. The balance of equities tips in its favor. And 4, that an injunction is in the public interest. This is a balancing test that means a strong showing in one area can make up for a weak showing in another. So let's step through it. First, are they likely to succeed on the merits? We need to look at each cause of action and see how that would play out. The first cause is the Computer Fraud and Abuse Act. So let me preface this by saying that outside of the research I've done for this video, I am not familiar with the Computer Fraud and Abuse Act. WP Engine argues that by coercively restricting access to WordPress.org, Automatic illegally restricted access to leverage monetary demands. So Automatic and Matt argue back that the act applies to hacking of computer systems, not restricting their own computers. In my opinion, it's going to come down to how the court interprets unauthorized access. From my research, this doesn't look like a good argument from WP Engine because courts typically apply the Computer Fraud and Abuse Act to hacking or unauthorized use, not simply access restriction. The next cause of action is extortion, and this one gets spicy. WP Engine contends that the defendants tried to extort millions of dollars for a trademark license that it does not need. Automatic rebuts with a legal argument that civil extortion is not on the books. That's a half-truth. Courts do recognize civil extortion, but there is a split on whether attempted extortion is recognized. Because they didn't pay, it would be attempted. Automatic also ignores Matt's statements and pretends as though none of it happened. Ultimately, I think that this is going to be a hard hill for WP Engine to climb. If they get the court to recognize the cause of action, and that is a big if, WP Engine needs to show that the coercive threats were intended to secure an unwarranted payment. The payment is unwarranted if Automatic doesn't have a colorable trademark infringement case. And for the most part, they don't. First, given that the WP Engine name has been used for 15 years, there's no real colorable claim that it infringes WordPress. Second, you're allowed to use trademark names in a description. What you can't do is use them in a business name, a product name, or a slogan. The one colorable transgression I found was WP Engine calling a product headless WordPress. That's not good. But given the ecosystem, it's far from egregious. So in my opinion, in most worlds, that relatively minor transgression would get Automatic off the hook for the extortion claim. The problem is that in this world, Matt talked all kinds of trash, and the crazy childish licensing agreement did not help. His vitriol and his actions don't align with the damage from the possible infringement. Moreover, Legal norms of a cease and desist letter, followed by months of back and forth good faith discussions, weren't followed. Matt's subsequent actions were completely out of bounds to remedy a possible minor trademark transgression. Thus, I think a fact finder, or a judge in this case, should find the trademark claim to be pretextual. It feels completely concocted, and it looks to me that the payment was not warranted, and attempted extortion is allowed. It's probably shown. Okay, so moving on, I think the next cause of action is a slam dunk: intentional interference with contract. WP Engine claims that Automatic tried to damage its relationships with customers and partners by undermining its ability to provide reliable services, specifically MAT statements and the WordPress loyalty pledge. Automatic contends that any interference was incidental and WP Engine's difficulties are self-inflicted. WP Engine was not, after all, guaranteed access to WordPress.org. To show intentional interference, WP Engine needs to prove that Automatic intentionally acted to disrupt WP Engine's relationships with third parties. All of Matt's statements, plus the crazy login loyalty pledge, makes this one, frankly, a slam dunk. Automatic and Matt tried to interfere with WP Engine's third-party contracts. There's really no question about it. And then finally, we have the unfair competition claim. The Engine contends that Automatic violated California's unfair competition law by blocking access, disparaging WP Engine, and expropriating its plugin. These actions were anti-competitive and intended to harm its reputation and economic standing in the WordPress ecosystem. Automatic counters that their actions are legitimate competition and that any harm is self-inflicted because WP Engine relied on WordPress.org, and by license, they could take a plugin for the good of the community. So in my opinion, Automatic has no argument for the plugin. Automatic makes an absurd argument that they had to take WP Engine's Advanced Custom Fields plugin because of a minor security flaw. Of course, WP Engine couldn't patch the plugin because Automatic had blocked access. In my opinion, reading through this is a complete construction, a completely made-up reason that they try to justify their actions with this silly excuse after the fact. I think it's a little bit closer call on the website access. WP Engine argues that they relied on promises that the website would be part and open for the community. But Matt counters there was no contract or license and access was at the pleasure of Matt and at the business's own risk. As I mentioned before, it's a terrible business argument, but it's not a bad legal argument. Anytime a litigant needs to rely on promissory estoppel, they're typically in trouble. But I think if there ever was a case where a litigant detrimentally relied on a promise, the facts here are pretty good. To be successful, California courts like to see harm to competition rather than a single competitor. Here, it's hard to argue that the ecosystem isn't damaged. Therefore, I think WP Engine's probably likely to win. Now, turning to the second factor of the preliminary injunction, will WP Engine suffer irreparable harm? Given Automatic and Matt's role as the WordPress gatekeepers coupled with Matt's rhetoric, it's hard to imagine that a simple check will adequately mitigate WP Engine's harm. If doubt is created in their customers' minds as to their ability to service their websites now and into the future, a check from Automatic probably will not fix that damage. I think this factor tips in favor of WP Engine. The third factor is, will the equities tip in favor of one party? Matt helpfully shot his mouth off and admitted that, quote, if we lose the injunction, what happens? Well, we'll have to go back to the state of what they were beforehand when they had access to WordPress.org. So that's fine. Clients like these are the worst. So by Matt's own admission, the equities are in favor of WP Engine. Finally, the last factor is public interest. This is where I think the granting of a preliminary injunction is frankly a given. For this suit, churches, restaurants, and other customers of WP Engine are part of the public, and they are collateral damage in this heavyweight spat. There is a huge incentive for the court to return the status quo pending litigation on their behalf. So what now? There's going to be a hearing in late November, and then there will probably be a decision shortly thereafter. So after reading all of the documents and reading a little bit between the lines, it seems like Matt is upset that WP Engine makes a lot of money off WordPress and doesn't get back enough. And looking at Matt's argument, I don't think it's without merit. I think that if he tried that case in the court of public opinion, he probably would have gotten pretty far and had still been the good guy. But he couldn't demand money from WP Engine for not contributing back to open source WordPress. So instead, he concocted this absurd WP Engine trademark dispute and ranted and raved like a petulant child, both in action and in substance. When Matt couldn't bully WP Engine privately, he started throwing levers to disrupt their business. WP Engine predictably, and in my opinion, justifiably, filed suit to ask the courts to intervene. But rather than cooling things down, Matt continued to write blog posts and hire lawyers. One side is fighting for their business, and in my opinion, the other is engaged in a pissing contest. So now I want to know, what is your take on all of this? What did I get wrong, and what do you want to know more about? Let me know down in the comments, and if you found this helpful, then please like and subscribe so I'll know to cover more about this case and other legal tech drama.